Okay, I think we can make a start. Before I pass the microphone over to Dr. Weiler, let me just draw everyone's attention. I think it's not going to be so relevant for the submissions that we're about to hear, and probably only now next for the closing submissions on Friday. But I've just had a plea from the interpreters that if you have a written script from which you are reading, please ensure that you pass a copy to the interpreters beforehand. I think they struggle, written scripts tend to be much denser, they struggle to keep up. So just a request that if there is a written script, particularly on Friday, that you pass that to the interpreters beforehand. Dr. Weiler, in the tribunal's letter to the parties which followed the pre-hearing organizational meeting at paragraph 7, we noted that of the 2.5 hours allocated to the claimants for their opening submissions, this may include a maximum of 30 minutes of reply submissions strictly confined to the issue of jurisdiction. I understand that that's what you're going to be addressing now.
It is what we're going to be addressing, but I am going to take some of the time that was originally allocated to Jeffrey in his submissions. I'm going to allocate, probably take about 15 of his minutes over, which I understand from the Secretary still leaves us with lots of extra time.
Well, let me just make the point that I think the tribunal is minded to exercise a degree of sort of flexibility, but as you'll recall from the pre-hearing organizational meeting, there was quite a lot of discussion about this, and I think it was quite clearly I think the agreement of the parties, which then the tribunal reflected in paragraph 7, that this should be 30 minutes and should be focused on issues of jurisdiction. So unless the respondent is minded to allow a degree of flexibility, I think that we're going to have to stick to what's in here.
Okay. My concern is that I speak very quickly, and I'm going to try very hard to speak slowly, but that might...
Well, I'm not going to encourage you to speak more quickly, because then we will have a difficulty. As I've said, the tribunal is inclined, as we indicated in the correspondence, to allow a degree of flexibility, but I do remind you of what was the agreement of the parties as reflected by the tribunal.
Okay. So with that, I'll begin. There's a couple of points I wanted to mention. Oh, how do we make this? There we go. First, I'm just going to describe documents that are being sent to you. These are actually not new documents. These are documents that appeared in your USB drives, but unfortunately only the first page of them, of the 4 or 5 of them, came to you in hard copy. So this is just the entire bundle of them. And so these are from our previous submission, I believe. Was this February or was this? This is the rejoinder, yeah. So nothing new, just...
Some uncertainty on the part of the Tribunal Secretary about these documents.
I think you're being handed our PowerPoint slides in paper version as well.
Perhaps you could just explain, we've got 2 sets, one with a paper clip at the top, which looks as if it's to be inserted somewhere. Is that not?
This binder? Okay,
in that.
at the very end.
And then what is that?
This would be those 4 pages I just mentioned. So you received one of them in hard copy and all of them in digital copy. And this is now to complete them in hard copy.
Well, thank you very much. In your own time.
Thank you. So before I begin, there were a couple of comments that my friends made about jurisdiction issues that I wanted to just address right away. I think the first thing to say would be obviously a party's comprehension of his claims or the responses are going to be shaped by the process of pleading, counter, reply, rejoinder. And I think therefore that generally as a rule, if you want the most accurate articulation of either party's submissions, you go to their last submission. So I would certainly recommend that in this case. I know my friends were more interested in quoting from earlier iterations, and I think that it'd be more useful to look at the parties' final arguments. Concerning my friend's claim about the claimants being barred from making claims about the new delay measures, he implies that we can't base our claims on these measures because there's a process that we must observe and that we didn't. And for that, he relies on the passage from Grand River in the jurisdictional decision in support. And it just so happens I was counsel in the Grand River case. And ironically, in that case, the claims that were not time barred, they actually were raised for the very first time by myself at the last 5 minutes of a 5-day hearing orally. And the tribunal accepted the petition for an amendment under Article 22 of the UNCT rules. So I don't think that would be the best passage to rely on for my friend's position. And further, I would note that in this case, we actually asked leave to amend our 2 statements of claim to cover these measures under Article 22 in our counter memorial on jurisdiction and reply on the merits. So to be clear, it was not raised for the first time in our rejoinder or today. It was actually as soon as we heard about it. So that would be my initial point, and then we'll just move on right to our slides here.
Mr. President, I object because I think Dr. Weiler is testifying as a witness about what he did or didn't do in another case. If the point is to be made here without testimony of a witness of fact, then we should be directed to the materials of the case.
Just read the decision. The decision actually describes the process, so you don't need my word for it.
I think we understand the point and we've heard what you've had to say.
Okay, so here there's 2 objections, both ratio and temporis. The one is about treaty non-retroactivity, and the other is about a 3-year time bar. The non-retroactivity objection revolves around how one would constitute expropriation, what constitutes a measure, what constitutes continuing or composite breaches, whereas the time bar obligation is interested in similar questions, but primarily in respect of what constitutes a breach in this case. It's also important to note that there are different perspectives that one takes with respect to these objections. They aren't identical. From the non-retroactivity perspective, you're really looking at the timing of the measures as alleged breaches, whereas the time bar objection has one looking at the timing of the claimant's knowledge of the alleged breaches. So there are differences, but the bottom line is that the breach is the most important element. So here in these first 3 slides, I've just set out the language of the CAFTA, and I'll just skip to the second slide here, which shows us Articles 1016, just 1016. So we see that the investment dispute is triggered when someone believes they have a claim, and the claim is based on when someone thinks there has been a breach of something. And then we'll click further. How do I click further like that? And we go further then, of course, to the most important provision in this regard, and that's 1018. And under 1018, we see that the question is, should have first acquired knowledge of what? Well, of the alleged breach. We would submit in this case, and we will explain within this presentation, why we're really not concerned in this case about the second branch of that test, about the knowledge of loss or damage. So when one wants to articulate what the breaches are, we've done it on a few occasions. Of course, we did it with these documents that we've submitted with a rejoinder, and we did it in the rejoinder, and I'm essentially, once again, putting them before you here. So there are 7 breaches. I styled them as 5 breaches in our memorial. Whether you call them 7 or 5, you'll see as we continue, is immaterial. But those are the breaches right there. And what I'd like to do is go through each breach and try to explain why these objections are not sustained based on the actual breaches that we have alleged, rather than the breaches that our friends would like us to have alleged. And there's the other 5. I'll give you the other 3. I'll give you a second to read them. So, with respect to the first one, so the respondent says that it doesn't matter whether it's direct or indirect expropriation, it always constitutes some single act in time, and therefore that it's merely a subsequent effect if you didn't pay enough or you didn't pay promptly. And I think our position is that if the respondent's argument were true, host states would always avoid liability. They'd have two ways of doing it. Either they could commit to a creeping expropriation and just never formalize it by transferring title, or they could declare an expropriation and just never pay. After 3 years, on their theory, they'd be set. They wouldn't have to worry about it. Basically, it would be a contest. You'd have to make sure that if the claimant didn't get in that period, they're out of luck. So we don't think that's their proper approach, and neither did the tribunal in IO European Group versus Venezuela. This is a award which was cited by our friends from the United States in their submission, which we received on Friday, and we had a quick look at it. It's in Spanish, so the quotation you're about to see on the second page is an informal translation with our friends from Google rather than anything official, and so I would recommend to you reading the Spanish version. But in a nutshell, we have a case in Venezuela where there was an expropriation decree and compensation, one would have expected determination of compensation would have been made through their process, which seemed to fit the international standards. And after 4 years, there was no determination. And the tribunal in that case thought that that violated the without delay provisions of that particular treaty, which of course are very similar to ours. So, and the quotation there is that the tribunal concludes that the Bolivarian Republic has not offered a plausible explanation justifying the delay of more than 4 years in fixing at least the fair value owed in compliance with the lookups, which implies that it cannot be considered to satisfy the requirement of Article 6C. Sorry. I think you actually should do it because I'm not doing a good enough job. And our friends also, I should mention, do cite this older case, which I think, from what I can see, is also very useful, and I thank them for that as well. It's another case that involves expropriation and then a delay in terms of the compensation being announced. The correct approach we submit is that the date of the breach is the date upon which an investor knew or ought to have known that an expropriation occurred without payment of prompt, adequate, and effective compensation. And with regard to the promptness, it must be done without delay. So all elements of that statement are necessary. None of them are superfluous. With regard to direct expropriations, the way that this would apply is fairly straightforward. Even if we were to accept, though, in our case, that the respondent was correct and that the direct expropriation was actually triggered and completed by a particular event, in this case, I believe they would say the decree of expropriation, it wouldn't actually matter. Let me rephrase, I'm sorry, I'm going to strike that. If one assumes that a direct expropriation takes place under Costa Rican law, that would be when title transfers, and that is Article 49 of the expropriation law, and that is the position of my friends in their memorials. So if we take that as the position, we don't have a problem with the 3 cases where we actually have that kind of direct expropriation, because in all 3 cases, that final transfer of title took place after the dates which are relevant in our case. The most recent one, I'm sorry, the first one was on June 29th, 2012. With regard to indirect expropriations, the problem with my friend's single moment in time theory is that it just isn't consistent with what all of the case law and the authorities, such as people like Professor Crawford, as we've cited in our memorial, they say that this is not a correct way to look at an indirect expropriation. Instead, in a case of indirect expropriation, it would actually be illogical to assume that the breach has occurred until actually all of the breaches which form, all of the measures which form the breach have actually occurred. And in this regard, we'd also just like to remind the tribunal, as we did in our memorial, that there is a difference between the parties' arguments with respect to the appropriate date for evaluation versus the appropriate date for breach. Professor Mendelsohn had a rationale in which he was responding to Judge Schwabel's opinion, and we adopt it for our own. We think it's quite useful. He points out that if the claimants still retain title in all of their lots, in the case of indirect expropriation, until there actually is a official transfer of title, well, if that's the case, then it's actually logically impossible for that breach to solidify until after title has been transferred. And so in that, if one applies that logic, the result would be that indirect expropriations never toll based on a 3-year rule, because they would be continuing until such time as compensation was actually paid. So that's why in our submissions, we talk about the totality of the measures which constitute interference which rises to a substantial level as being an appropriate point at which one could bring a claim. But because title is perennially non-transferred, as a result, during this whole period, after there has been that level of substantive interference, during that whole period until they actually transfer title, you have a live breach, and therefore you can't have a problem with a time limitation. It's an ongoing breach. And we definitely support that. How am I doing for time, by the way? Okay, good. And so in this case, we have a few examples here. We have Satena adopting these temporary annual moratoriums on accepting environmental permit applications. And it's a little murky as to exactly the basis upon which they did it. From the best that we can grasp from the record, essentially, they referred to the 1-year suspensive effect rule in the expropriation statute and just reapplied it annually. Alternatively, they did it once and then just sui sponte actually maintained the suspensions annually on the basis of some expected or pending court decision. So it's not exactly clear how they did it, but what's clear is that it was only ever temporary, and it didn't actually become permanent until after the Constitutional Court had had its say multiple times. And as we've described in our memorials, in the case of the Constitutional Court, we have in May, it's saying to the government that it has a choice. Either it expropriates or it provides compensation. It's got to do one or the other, and it's got to move. And then in December of that same year, just a few days actually, just a few weeks before the CAFTA comes into force for Americans, the court now says, no, you have to do it immediately. And so that concerns, obviously, I think rightly so, that concerns both Menai and Satena officials, which is why in January and February of the following year, just about a month and a half later, they write to the court and say, we think your decisions are contradictory. We need some guidance here. Which one is it? And the court, amusingly enough, said, no, we actually think it makes perfect sense, and you should know constitutionally that you have the discretion to decide when and how to expropriate. That's not our job. We just tell you you have to do it. So the court's explanation essentially modified its December decision to take the immediate out of you must expropriate. So interestingly enough, it's another year before the minister actually gets around to doing that. It's not until March 19th, 2010, that the minister actually exercises that discretion and makes those suspensions permanent, which of course is an element which is necessary in finding an expropriation. There has to be an element of permanence. It can't be ephemeral, it must be permanent. So we now have a very nice peg along the road towards expropriation with the minister's decision. So when one, though, is trying to ascertain whether there has been an indirect expropriation, we now know that we have a suspension which effectively vitiated the claimant's rights and property. And we now know that it became permanent as of March 10th. But what we don't know, if we put ourselves in the claimant's shoes at that time, is whether the government is actually going to own up, follow this decision, and actually either change the law, as the environment minister was attempting to do at the same time he was issuing this order. He and the president were both actually working hand in hand with the claimants to change the law so that they actually would be able to. And I should say, change the law as interpreted by the court rather than change the law as it was written. So from the claimant's perspectives, if you put themselves in their shoes, they have court decisions going this way and that, and then they don't know, of course, about these letters that have been made by the two ministries asking the court to clarify itself. And they don't know about the court's clarification. All they know is that in the middle of working with the president's office and the minister's office issues this final binding suspension of all consideration of application for environmental permits. So from a claimant's perspective, what are they to do? They've got the very same ministry doing one thing and another, which seem completely at odds. I think probably they were really just covering both of their bases because the new administration was about to come in. And they know that there's a good chance that because the president is in support of the measure that would allow them to continue and sustainably develop their land, why would one think at that point in time, or perhaps I should say, why would a reasonable claimant in those circumstances be held to assume that it was at that very point that they actually had to make their decision, that their claim told from that day? It would seem to us that it would make a lot more sense that we would want to put ourselves in the shoes of the claimant, not in the shoes of a lawyer looking at it years later, and say, well, probably as of that date, whether it be March or whether it be May or whether it be June, they were probably quite hopeful that this was all going to get sorted out. And of course, they have promises, all sorts of promises from the others, from Costa Rica, saying, don't worry, at the end of the day, our statute says you're going to get paid, you're going to have compensation, it's going to be full, adequate, and effective. Well, how are they to know at that date? On the other hand, go about a year forward after the Chinchilla administration has been in, there's no new bills, everything looks pretty firm. I'd say that with about a year after that, let's say sometime in March of the following year, it looks pretty desperate for them. It looks like nothing's going to change. There's not going, the government's going to be in force for another couple of years. That's probably a good time to suggest that that's when a reasonable claimant would have actually been expected to make a claim. So I'm going to skip forward now just a couple of slides, and just for the sake of the record, I've been talking about these slides without clicking them forward. I'll move to 2 and 3, the second and third. And this is a point which I wanted to just stress. Thank you. This is a point I wanted to stress as quickly as I could with respect to something that my friend said. He mentioned the idea that a claimant is not allowed to say, I need to wait until I know exactly how much my damages are. And he cites quite properly Bill Kahn and a few other tribunals for that position. That's all fine and dandy, but that's not the problem we have here. The problem we have here is whether or not the breach should be known or should be constructively known because it's the breach that's relevant. It's about compensation. There's an actual formula in the treaty and a formula in customary law that says what one must do to satisfy this compensation standard. The only way one can know whether or not that obligation has been fulfilled is if an offer has been made. If a determination has been made and the number is X, and from the reasonable investor's position, it should have been X plus 2, well then that would be the moment at which one would expect them or construe them to have knowledge. But until they've actually told you what the compensation is, you can't know the breach. This has nothing to do with what the loss or damages are. It's got to do with whether there's been a breach. So this is a kind of provision that does not lend itself to the analysis that my friend would like to have it apply to. Now, with respect to the fourth breach, we don't have a clear methodology from the respondent on this. And this is basically the question of how many breaches we actually have here. We know that in the text of the treaty, in the annex, that it specifies that Article 1017(1) constitutes customary international law. It doesn't say 1 and 2, it just says 1. So based on the language of the treaty, it appears that the other provision, section 2 or paragraph 2 of the same article, must mean something. It has to have some sort of meaning. And interestingly enough, if you look at that provision, it actually specifies what prompt means. It means without delay. Okay, well, we have more information than we did before. It means that you have to satisfy a promptness standard and you have to satisfy a without delay standard. And that appears to be what the tribunal in that recent Venezuelan case did. It asked itself what was the test for without delay. At least we know from them that 4 years is too long. And in our case, we've got lots more than 4 years. In that regard, I should also mention, just because it has come up a few times, to be clear, in our case, we don't ask you to toll the delay meter, if you will. If you think of the taxi analogy, you don't start the delay meter until the CAFTA comes into force. Because before that time, we just know there has been a delay. You can certainly take notice of the fact that there had been a delay because that's what's continuing. But you actually only start the meter running at the point where the obligation is actually in force for the respondent. And that, to be clear, that's the meter for the retroactivity objection. The meter for the 3-year time rule objection is a little bit about a year further. That one is June 10th. Yep, June 10th, 2010. So I would leave it to the tribunal to decide whether it prefers the first or the second. Ultimately, you might want to apply, there's an argument to be made that it actually should just be the delay counts from the day the obligation was in force. I think actually, I take it back, I wouldn't leave it to you. I would actually say it's got to be that day, and the reason why is the time limitation question isn't about when the breach occurred, it's about when knowledge of the breach or constructive knowledge of the breach would have happened. So you count the timing of delay from 2009, which means today, in the cases that we have going forward right now, we're into 7 years. So we're way past the 4 years of this tribunal. And again, I've sped past my slides again. Let's move to number 5 here. So the indefinite delay. This is the Controlleria report, and this, of course, these are the new measures. And with respect to the new measures, it's important to note, this is an interesting test because we don't know exactly when they came into force, and we don't have all the documents one would have expected to be attached to the witness's statement to actually articulate these standards. We get the idea that it was sometime in 2008, roughly around the same time as fairly big administrative valuations came in on 4 lots. Coincidentally, it's right around that same time that they decide that in anticipation of the auditors doing work, that they should really suspend everything. keep in mind, the controller RIA actually never did ask for that suspension, or at least it's not on the record. So in anticipation of the controller RIA wanting to potentially suspend, they claim that they suspended. Was that in 2008 or was that in 2009? I don't know. Luckily, it doesn't matter because we know that in 2010, they tell us, after the controller RIA had finished the report, even though it never did ask for suspension even then, they decided to keep suspending because they wanted to implement all of the controller RIA's report recommendations. Interestingly, one of those recommendations was to use other legal processes to try to invalidate title for everybody who still has land to be expropriated. That hasn't happened in our case, but it's just interesting that that's one of the recommendations. We don't know if that's one exactly how one actually implements that or if that's what's holding them up. But for some reason, they can't tell us at what point they're going to start going again, but we do know that from 2010, which is after the CAFTA came in, they made a decision, which clearly constitutes a measure under the CAFTA, that they were going to not do anything about half of the cases that are involved with our clients. All the ones where there has either only been an expropriation decree or the ones even earlier back in the process that have only had a public interest notice. So that whole group of cases, they seem to be in this permanent state of stasis, I guess zombified. And we don't know when they're going to end, but that's what we mean by delay. And that delay, we would submit, is so arbitrary that it's not just a breach of Article 17(2)(b), it's also a breach of the minimum standard of treatment, because it's simply not fair and equitable to come up with a notice, with a suspension, without giving any notice to the people who are going to be affected by it, and to not even mention it to them until they sue you. And then you mention it to them within the course of your pleadings. And the basis for it, we just don't have enough information from the respondent to be able to tell us if it's actually rational. It really doesn't appear. It appears that based on the evidence we have, that the reason they really did it was because they didn't want to pay those 4 administrative appraisals, which were about $400 a square foot, which was a lot more than the previous ones. It's not even half of what they should be paying, but it's substantially more than what they thought they were going to get and what they got from the other appraisers. So moving on to 6. This one, we don't need to go into too much detail. You've seen this in all of our submissions. We basically say that fair and equitable treatment is violated when due process is not provided. And we also say that fair and equitable treatment, evidence of fair and equitable treatment being not provided can be manifest in the arbitrariness of the results of a process. So for example, the crazy high and low numbers that were coming in and seem to still be coming in, that arbitrariness is a hallmark of a lack of fair and equitable treatment in a process. We also say that that process itself, because they're providing a process that in fact is completely inferior, even though just like the Soviet Constitution looks great on paper, that also is a failure to provide access to a process as required under the customary international law expropriation standard, which says you must give access to a process that gives you prompt, adequate, and effective compensation. The same is true with our detrimental reliance allegations. Again, to be clear, we're actually not making an allegation that detrimental reliance is a delict in and of itself. It isn't. It is simply a doctrine, much like the abuse of rights doctrine, that can be used to demonstrate in the analysis that a tribunal undertakes whether or not something is fair or inequitable. It may be in some cases that detrimental reliance is not relevant to a fair and equitable analysis, but sometimes it is. We submit that in this case, it is, just like in the Bilcon case. And we would certainly commend to you the Bilcon analysis with respect to this area of FET, because in that case, they did actually believe that or find that legitimate expectations included the general category of expectations. So this general category would include the laws as they found them, the regulatory environment and the regime that they found. Obviously, they don't get any kind of guarantee that it's always going to stay the same, but by the same token, they do have some expectation that if the law says X, that they're not going to get Y. So just like in BillCon, we submit that that evidence in this case is useful for you to find an FET breach. It's particularly useful in the case of Brett Berkowitz and the Berkowitz claimants because, as the record definitely demonstrates, he went to the minister before he went all in on his investment and asked, am I going to be able to do this? And when he did that, that was at the time when the minister was, of course, the minister kept changing his mind, but, or maybe he just was of two minds at the same time. But this is at the time where we know on the record we have him saying, we're going to do sustainable development. We're going to get this so that you guys are going to be able to go ahead and do a sustainable construction of your homes. So it only makes sense, given the documentary record that we have, that that meeting actually did take place as it was recalled by Mr. Berkowitz. And if that did indeed happen, that is a quintessential example of something that you can rely on, that you can take to the bank. It comes from the environment minister. So if the environment minister's promise to you that you are going to be able to go ahead isn't worth anything, then I don't know what is. So I'd say that that's a great example of why his detrimental reliance demonstrates a breach of the FET standard. And with that, I've reached my 30, I'm probably 31 minutes right now, and I've finished.
I was just going to say that you've hit the buffers. We'd give you an extra minute or two if you wanted flexibility, but
No,
if you've finished.
I hesitate because I know my friend is worried about too many slides that weren't spoken to, but I would feel comfortable that I've actually addressed all of them, even though I didn't hit the button often enough. So thank you very much.
Thank you all very much. I take it that that's sort of the end of the formal submissions of the parties for today's session. There are a number of housekeeping issues that I'd like to address with you all before we bring today's session to a close. Really, all of this is in prospect for tomorrow. I indicated at the start of today's session that we would begin tomorrow's proceedings with the oral submissions of El Salvador as a non-disputing state. I'd like to ask the Council for El Salvador, you indicated to us previously that you would like 20 minutes. Would you like to just affirm or revise that time period simply for our planning purposes, please? And in just a moment, I'm going to ask the United States whether you want to make an oral submission as well.
Thank you, Mr. President, members of the tribunal. I would like to affirm that I will not take more than 20 minutes tomorrow on El Salvador's oral submission.
Thank you very much. As I'll remind you all, we'll start tomorrow at 9:30, and I think we will start with El Salvador's oral submission. United States, would you like to you've reserved your position on whether you want to make an oral submission as you're entitled to do under the DR-CAFTA?
Thank you, Mr. President and members of the Tribunal. The United States does not intend to make an oral submission tomorrow. We thank you for having accepted the written submission, and we would just respectfully reserve any rights under the treaty.
Okay. Thank you very much for that. So we have a starting 20 minutes with El Salvador. I indicated also in opening this morning that I anticipated that the tribunal would have a number of questions arising out of today's session, and I think I can say, without conferring in detail with my colleagues, that we are likely to have questions that we would like to put to you. What we propose to do is to put those questions to you tomorrow after El Salvador has made its oral submission. Invite you, if you would like to spend a little bit of time actually addressing such questions as you may want to there, either in whole or partially, and if you would like to reserve the opportunity to either address them completely or return to them, at the time of your reply submissions on Friday, that'll be fine as well. But I think this is really for purposes of giving you as much advance notice of some of the issues that are concerning us in the light of today. I remind you that if you do have any applications, motions, objections in prospect of the witness testimony that's going to begin tomorrow, this is the opportunity, if you've got them already in mind, to raise these with us in a timely fashion. I'd like not to be in a position where we're bumping up against objections which you've been sitting on for some period of time, but only make them as the witness is called. So if you have in mind any objections at this stage, or applications or motions, now's the time to raise them. Of course, if they only occur to you tomorrow, you can raise them tomorrow. But let me just pause for a moment and ask you whether there are any pending motions, applications, objections.
I'm not sitting on any objections at present, Mr. President.
Thank you. That's helpful to know. We've got. Sorry. Yes, you're right in saying that we should get Mr. Alexandrov's shaking of his head negatively on the record.
We're not sitting on any objections at the moment.
Thank you very much for that. After the questions and any answers tomorrow morning, we'll be moving to the claimant's fact witnesses. And I think we have them, if I'm correct, in the order of Mr. Reddy, Mr. Berkowitz, and then Dr. Rusenko. Is that correct?
Get it on the record rather than...
Yes, that's correct.
That's
Mr.
correct.
President.
Thank you. We've set this out in correspondence to the parties previously. I'd just like to remind you that although we, the tribunal, will proceed with a degree of flexibility in terms of timing, so this is not going to as it were, bind you in an inflexible way, but we would like to endeavour, if at all possible, to ensure that witnesses do not unnecessarily straddle the lunch break or the break at the end of the day. I appreciate that this is going to depend on the cross-examination and any re-examination that might follow, but I just urge you to take that in mind, keep that in mind. One last point, I think, to draw to your attention, and the members of the tribunal have discussed this previously in the light of the reservation of rights to object on the part of both parties. As we move into the witness testimony tomorrow and in the coming days, we will, of course, entertain whatever objections you may feel that you want to make. But just to put down a marker at this stage, our inclination is to allow a degree of flexibility. We don't propose to run this like a US courtroom or a common law courtroom. But needless to say, if there are objections, we will consider those objections as made. So I think that's it from me. Remind you that we're starting again tomorrow at 9:30. But let me just ask the parties whether there is anything of a housekeeping nature that you'd like to raise at this stage before we close.
Just one brief matter. The sequestered witness, Dr. Rusenko, we haven't met to prepare his brief chief, and we intend to do that this evening. We will respect your ruling, of course, and not inform him of anything that's happened in today's hearing by way of openings or otherwise. But we will, of course, develop his evidence in chief this evening and respect that limitation. I just bring that to your attention because practice on that does vary from jurisdiction to jurisdiction.
Thank you very much. I mean, the tribunal has reflected on this previously, and I think we've come to the conclusion that we are not in a position to, as it were, police the sequestration. It's the reason why I admonished you, the claimants, right at the start of this to ensure that Dr. Rusenko was aware of the requirements of his sequestration, and as counsel before the tribunal, we will assume that you will proceed accordingly. Mr. Alexandrov, any issues that you would like to raise before we close?
No, Mr. President.
Well, thank you very much then. We'll reconvene tomorrow at 9:30 with El Salvador's oral submission. Thank you very much.